people ask me, what is the process? And Tessa's really wanted me to focus on the process of how you get divorced and some of the important things to consider. So the very first thing, once you have decided to file for divorce, is to file what's called the petition for divorce. And we have a waiting period in Texas for divorce, regardless of why you're getting divorced. We have a waiting period that says you cannot be divorced for 60 days, with the exception of a few, there's a few minor exceptions, but generally we have a 60-day waiting period. And that filing of the petition, that petition for divorce is what I tell my clients, it is the wish list of everything you want the court to give you. Now, sometimes when you hire an attorney, y'all will talk about strategy on what you put in that petition for divorce, because you can make it what we refer to as a more friendly petition, meaning you don't expect to fight. Maybe it's going to be uncontested, or there's just a couple of issues. And so maybe you want to go in and just say, Judge, we're going to reach an agreement on everything, and we just ask that you approve it, all the way to we hate each other. Potentially there's physical abuse. There's people having, girlfriends or alleging that people are wasting funds. We need a kick out order to get people out of the house. There's lots and lots of issues going on. So you may want to make the wish list of what goes into your petition a little bit stronger or more specific on what you're asking for. It's important that you understand that if it's not in that petition for divorce, the court cannot grant the relief. So if you want to be have a geographic restriction, which we'll talk about in a few minutes, on where somebody is going to be able to live with your children, it has to go into the petition for divorce. Once you have that petition for divorce filed, you will get assigned to a court and have a case number assigned. That is the court that you will be in forever and for always. Your judge may change, but your court will stay the same, assuming all parties continue to reside in the state of Texas and in the county that the divorce is issued in. If you move, then there may be an ability to transfer. But generally, the court that you're assigned to for divorce becomes your court of continuing jurisdiction for all future child-related issues later down the line. And in Harris County, and I'm not sure, Marianne, where you're from, but in Harris County, we have 10 family district courts. I also am active in Montgomery County. We currently have 3 courts up there, 2 that are pretty much full-time family law, and another one that's continuing to add more cases. And then in some of our other surrounding Northwest counties, we maybe only have 1 district court judge that hears everything from family law to criminal law. But once you file that petition for divorce, you have to notify your spouse that you have filed for divorce. So there's really 2 ways to do that. The most common way to do that is to do full-on service. So that means you're hiring a constable or you're hiring a private process server to go out to serve in person your spouse, and that notification is going to say you have been sued, you have, here is a copy of the divorce petition, and now you have an answer period of a little longer than 20 days, depending on when you're served. The more friendly option is what we call a waiver of service. A waiver of service, when you're in an uncontested divorce, you're not really fighting, everybody is getting along. That waiver of service is something that the other party or the respondent can sign in front of a notary that says they've been given a copy of the petition for divorce and they don't want to be served, even though that's their ability or their right. And once that waiver of service is filed, that serves as their answer and appearance in the divorce, and you can move forward. Now, something that is new that would be the next step after filing the petition and serving the other party is once the other party, your spouse, files an answer or a waiver, then from that point, there are 30 days to do mandatory document disclosure exchange. And this is a new legal change that went into effect January 1st of 2021. Tessa, if you would change me to the next page. And I should say, I don't know where everybody is from, but this is Texas law. I know that we have the ability to have people dial in from other states. So know that this stuff that I'm talking about in regards to mandatory disclosures and the process for divorce is specific to Texas. So beginning January 1st, unless both parties agree to waive this requirement, there is an obligation to exchange documents. And there's a laundry list of questions or areas that the attorney will answer, but these are the documents that are going to have to be provided to your spouse or your spouse's attorney within 30 days before any other discovery can be done. And most people want to have this done before you would go to a temporary order or a mediation or any of that, which we'll talk about shortly. So in a suit for divorce, you'll see that you have to be prepared to provide the last 2 years of data of any real property that's owned or leased, any retirement plans, statements for 401ks, IRAs, stocks, any statements for insurance policies. So that would be life insurance, house insurance, etc., and any bank statements. And that's all bank statements, whether your spouse is on it or not. So if you have an account and your spouse has an account, and you have a joint account, you have to trade those documents, even if they have the right to get them themselves, even if they're on the account. The Supreme Court got tired of lawyers and people not trading documents, and they just said, everybody's going to do it, and you're going to do it completely. So if you're going to get ready for a divorce, these are the kind of documents that you're going to need to have available relatively quickly after the divorce is signed. I'm sorry, after the divorce is filed. That's for any divorce having to do with property. Now, divorce is really two suits in one. There is the act of dividing your marital property, which we'll talk about in more specifics in a minute. And there is the suit involving your child. In a divorce, you're dealing with both of them. Now, sometimes people have kids before they get married, or they have an order previously through maybe the Attorney General. It's called a SAPSR, or a suit affecting the parent-child relationship. That would need to be incorporated into your divorce if that was something you did prior to getting married or filing for divorce. If you've never done that before, then your divorce is going to be where you address all of your kid issues. So if there are kids of the marriage that are under the age of 18 or who have long-term disability, then you'll additionally need to provide proof of health insurance and how much it costs, the tax returns from the previous 2 years, and your 2 most recent payroll check stubs. And that is so we can help to figure out child support and, in certain situations, spousal support. Next. Okay, so in those very contested cases, after you filed the petition, after there's an answer, after you've done the mandatory disclosures, in certain cases, you're going to want to ask for temporary orders. Those temporary orders were asked for all the way back when you asked for your laundry list or wish list from the court. And you do these when you don't think you can figure it out on your own, or you need the court to set some rules while the divorce is pending. So certain things that would be up for discussion or consideration for temporary orders would be things like who's going to remain in the house during the pendency of the divorce before the divorce is final. Who's responsible for paying the bills? Even if you're not living there, you might be ordered to continue to pay the electric bill. If your spouse has been a stay-at-home parent for the duration of your marriage and now you're getting divorced, the court is likely to say she gets to stay there or he gets to stay there with the kids and you get to pay for it. Sometimes we have interim spousal maintenance, which is above and beyond bills. You're paying your spouse a certain amount every month. And you could also be ordered to pay attorney's fees. These are all of the issues that go into, who has access to the money, who has the ability to make the money. If both people are making a good living, usually the court will say you pay yours and everybody pays their own. But sometimes that's not the case. And so a temporary order is going to set those rules on the property side. Additionally, the temporary order can put some orders in place for children issues. So who's going to have primary custody while this is pending? Where are the kids going to live? Is there going to be child support ordered during this temporary period, and so forth? What's the visitation schedule? So a temporary order is like a hard down divorce order, in that it is addressing property and kids and so forth. But what it's not is it's not a final order. And you do this because there's an emergency situation, or there's a lot of discovery that needs to happen, and you need to make sure that the assets are being protected during the period of temporary orders until we can get to final. I would also just briefly add that in certain counties, there are things called standing orders, and that is orders that apply to every single divorce in that county that are set by the judges in advance, and there's really no wiggle room. And those are things like nobody can hide the child from the other person. Nobody can turn off the utilities. Nobody can sell any major property, etc. Those are what we call temporary injunctions or standing orders, and could apply in your case depending on your county. It's important to understand what they are based on where you live. So once you've done temporary orders, if it was necessary, again, it may not be necessary for your case. You've done your mandatory disclosures, and now, okay, you're ready for final orders. People ask me, how fast can I get divorced? Well, like we started, it's a minimum of 60 days. On average, it's longer than that. It really depends on what property you guys have, what is your specific situation. If there's a lot of assets, then there's going to be more expansive discovery that may be necessary beyond those original initial disclosures. So that could be more document exchange. But what you have to think about in discovery is, if the other side asks for it and you don't give it to them, your attorney cannot use it at trial. So if you want to prove that you're the more active parent, and you plan to introduce evidence that you're talking to the teachers all the time, and you're talking to the counselors, and you're talking to the doctors, and your spouse isn't doing anything, and you plan to introduce that at trial, and they ask you for, prove to me how you're a better parent, you have to give them to them. That is what the expansive discovery may look like. You could also have to do depositions. That's like when lawyers get in a room and start asking you questions, like if you're on trial, that goes on the record. Generally, that's for very high net value divorces or very contested custody cases. But it is something that would extend how long it takes to do a divorce and would add to the expense of the divorce. If we can't agree on the value of the house, there's a lot of properties that have raised dramatically in the last 6 months, especially with COVID. So we're doing a lot of real estate valuations, and that's slowing down how long it takes us to move forward with divorce, because the realtors are just very backed up. If there's businesses involved, the court is often going to want you to do a business valuation. There may be the need to do forensic accounting, which Tessa might talk to, but that's like figuring out whose property is whose and who's spent what. These are all things that are leading up to the last bullet, which is mediation for final orders. And I know we have a mediator on who's going to talk about that process, but it is something that every court that I practice in front of, with maybe the exception of one, requires all cases to go to mediation and attempt to settle the case before you can go see a judge. And if you don't go to mediation before your trial date and you don't have a good reason why, the court can dismiss your case. So mediation is very much a part of this process. Next. Just quickly, these are final ordered child issues. A lot of these are going to be similar to what we talked about in the temporary orders, but the final orders are going to say, do you have joint or sole custody? who has decision-making abilities in regards to invasive procedures, education, and so forth, and what kind of visitation schedule is the other parent going to get when it's not your turn to have the kids. So that's just kind of an overview of what that looks like. Additionally, go ahead, Tessa. Of course, we need to talk about child support. There's really 4 kinds of child support in Texas. People don't think about this, but there's the periodic monthly child support, which is based on income and is a formula based on how many kids you have and how much you make. There's also medical and dental support, which is the parent who's not primary gets to pay for the child insurance typically. And that gets paid back to the other parent, or they have to provide it themselves. And then out-of-pocket medical is usually split 50-50. And then in regards to property, you have to understand, and I know Tessa will talk about this, but separate property versus community property. Texas is a community property state, and the court can only divide your community property. That means you have to prove if it was owned before marriage or inherited and is maybe your separate property, you have to prove to the court that that is in fact the case. Otherwise, it's subject to division. That's all your houses, your cars, your toys, your retirement, your bank accounts. People who are stay-at-home parents are equally entitled to everything that you have in your 401k if you were married for the duration of the time that they were working there. Debt is also something that must be considered. And then if you've been married for longer than 10 years or there is a disability that needs to come into place, spousal maintenance is also something that the court can consider. And then when you're wrapping up the divorce and you get to a final agreement that addresses all of these issues, you need to finalize the divorce decree. It gets signed by all the parties. And then depending on what you're trying to do, there are some other documents that you need to make sure your attorney takes care of. Child support documents, including wage withholding orders, quadros, which are a separate order to divide any retirement that might be awarded to another party. If people are currently on a deed and they need to come off of a house, then you need to file new deeds. And you may also need to take care of removing people from cars through vehicle powers of attorney.